and we're off courtroom tension brewing already. The judge is calm, but notice that good luck tone. It's not just polite, it's foreshadowing. Someone's about to learn a hard legal truth.
Good luck to you, sir. You can go back with the bailiff.
Okay.
Yes, sir.
I think Mr. Parker might be really good.
Oh, you're funny.
I'm getting there. Let's
I'm in
see.
no hurry, Judge. It's not like robust.
That's not what he was saying earlier.
I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in county court 2 the other day, and it took literally 20 minutes to make this, literally 20 minutes. And I was doing rejection. He tried to say, I believe it. I'm gonna go get on Zoom and beat you. So I approached the judge after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he had to wait another hour.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
All right. Pause for context. Competency to stand trial means the court's making sure the defendant understands what's going on and can participate in their own defense. You can't just drag someone to trial if they're not mentally fit. It's a constitutional safeguard.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Gron. I've received that report dated August 13th of 2024. Dr. Gron made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand what could happen if you go to trial and you're found guilty?
And here's where it gets real. Mr. Kane tries to explain his side, but the judge redirects him immediately. Classic courtroom moment. What you think happened doesn't matter here, only what can be proven. Ever been in a moment where you just wanted to explain yourself, but the system says, not now? Yeah, that's this.
I understand, but can I ask you a question?
Sure.
If I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing, what happened surrounding this offense or what they've charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get a.
Here's the thing. Well, here's the thing. The offer is, I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand, if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that concerns he's had with Mr. Nichols and explained to him the situation after he's had evaluated. I've again to talk to about the offer, and Mr. Nichols has remained steadfast on the offer that he's made previously, which is the offer today.
Okay.
Judge, just so that you're aware, it's not his first offense. He was actually before you in 2018.
Okay.
So they think for
Burglary of a building, it sounds like.
the state jail felony was
Mm-hmm.
it was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case. as far as what she's saying.
Look, regardless of that, that doesn't change even if you had it, it doesn't change the punishment in this one. Okay. That can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Might I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
It was a, sorry.
Go ahead.
It was a felony conviction with,
Quick breakdown. The judge and attorneys are sorting through Mr. Kane's prior record. Terms like state jail felony and 1244A are getting thrown around basically. It means he had a felony that was punished locally, but it still counts. You can feel the frustration he thought it was dismissed. Spoiler, it wasn't.
county jail time, so he may misunderstand that he is already a convicted felon.
Okay, so it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So I got 1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction, but we're going to stop talking about that because it doesn't matter right now.
I was attempting to find out because I ended up going to Judge Green Woods for like.
That's misdemeanor court.
Exactly, for the reduction of.
Listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, second degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it or do you want to let a jury decide?
How much back time?
Well-
How much time would I actually have to do?
I've discussed that with him this morning, Judge.
Okay.
He has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen,
I didn't get
don't
a
talk
date.
up-
I was attempting
don't talk over me.
for school, so
Listen.
I'm trying to figure out.
Listen and don't talk for a minute.
And right here, the judge takes command. This is the pivot she's done with back and forth. You'll notice judges often step in like this when they sense confusion or circular debate. The courtroom isn't a conversation, it's a process. And this judge, she runs a tight ship.
Because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk, she has figured out your time, how much credit you have. I don't know how much time, he doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it. If you do, that's up to you and how you behave. I need to know if you want to take that or if you want to go to trial. So what do you want to do?
So can I ask you another question?
Sure.
So you said a quarter of it I'll be eligible for parole.
Mm-hmm.
But he said I have 100, you know what I'm saying, 100 days.
Yeah.
Back time. So
Okay.
I already did, like 6 months now, and I got 100 days back time.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, it's a quarter of 5 is
About a year and
3/4.
about a year and 3 months.
So you know.
I was trying to make sure. That's
Well,
all.
We're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if he would get out if he took the deal, and I said you would not get out
No,
today. And
you don't get out today. You got to go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case, you understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today, because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either...
Oh, boom, there it is. The judge draws the line. 5 years today, or the deal's gone. This is what legal pros call the plea deadline. It's a strategy, push the defendant to decide under pressure. But here's the question. Is that justice or just leverage? What would you do if the clock was ticking on your freedom?
We're going to have a jury decide, which is fine, or the deal's going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today, because after today, 5 years is gone. What you want to do?
Let's see. So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial, and you'll be up for trial whenever the next available trial docket is, and a jury can decide if you're guilty or not. And if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
I'm saying if anything, he used excessive force, and it's not necessary. So
Well,
I have to get retaliation for public service.
we're not negotiating. Mr. Kane, we're not negotiating. You and I aren't negotiating today. The negotiation's done. Do you want the 5 years or do you want a trial?
You say the trial will be within like a year?
I have no idea when it'll be. It'll be the initial, I mean, it just goes on the trial docket with everything else. And as soon as it comes up, if it's number one that day, it goes. It depends on how old the cases are. It depends if somebody's in custody. It depends what type of case it is. So I can't guarantee you when your trial will be. I would like to think it would be, but no, a year or less, but I can't for sure tell you that. We're doing really good with moving trials, do the best we can, but I can't tell you for sure when that would be.
Question, but one more question, and I'll let you know. On that burglary on
We're not going back to that. Just let me know. We're not, no, we're not going back to a burglary. Okay. Do you want the deal on this one or do you want to go to trial?
Huh?
Do you want the deal on this one or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right. I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning and then I'll take care of it in a few minutes.
Can I plead not guilty?
No.